There is a position inside the United States Senate called the Senate Parliamentarian. No law established it, no senator confirmed the person who holds it, and that person has decided the fate of major American legislation for decades without a single public hearing. The office has existed since 1935. You were never told it had this much power. Here is what it literally is. The Senate Parliamentarian is a staff employee, not a senator, not a cabinet official, not a federal judge. They are hired by the Secretary of the Senate, itself an appointed, not elected position, and they serve without Senate confirmation, without a fixed term, and without any public accountability mechanism. Their job, on paper, is to rule on questions of Senate procedure. But in the modern Senate, that function has become something far larger than procedure. It has become a gatekeeping authority over which pieces of legislation survive long enough to receive a vote from the people you actually elected. The office was created in 1935 by an internal Senate resolution, not by an act of Congress, not by statute, not by anything bearing a presidential signature or ratified by any chamber in the constitutional sense. The Senate simply decided internally that it needed a referee for its own rules. And then it gave that referee binding authority over the legislative process. The power expanded quietly. For most of the 20th century, the parliamentarian's role was narrow: catch procedural violations in real time, keep the floor moving. When budget reconciliation became the primary vehicle for passing sweeping legislation with a simple majority, the mechanism both parties now rely on to move major bills, the parliamentarian's function transformed into something the 1935 Senate never publicly articulated. The specific rule the parliamentarian now enforces is called the Bayard Rule, named for Senator Robert Bayard, added to the Congressional Budget Act in 1985, permanently codified in 1990 under 2 U.S.C. Section 644. The Bayard Rule says anything in a reconciliation bill that is extraneous to the budget must be automatically stripped out. The parliamentarian decides what qualifies as extraneous, in private, before the vote, with no public record of the deliberation, and no right of the public to observe the process that just removed the provision you may have written your senator about. Here is the part that should make you stop. This means that a staff employee, one person, unelected, unconfirmed, appointed through an internal Senate process, has ended the legislative lives of provisions that held majority support in both chambers of Congress. In 2021, a federal minimum wage increase to $15 was ruled extraneous under the Bayard Rule. It had the votes. It did not have the parliamentarian's approval. It was stripped from the bill before the vote occurred. No senator successfully overturned the ruling. Remember, no one voted for this arrangement. Overturning a parliamentarian ruling requires the vice president, sitting as presiding officer, to reject the interpretation from the chair. It has happened, rarely. And here is the part that should actually worry you: it is completely legal. Every step of this process is technically permitted under the Senate's own rules. The mechanism was never designed to be hidden. It just operates in a space the public was never taught to look at. The Senate parliamentarian's authority does not derive from statute. It derives from precedent, the accumulated rulings of previous parliamentarians, treated by the Senate as binding interpretation, passed from one occupant of the office to the next like inherited law. There is no external court that reviews these rulings. There is no public appeals process. There is no sunset clause. When the current parliamentarian rules on a provision, that ruling joins the body of Senate parliamentary precedent. The next parliamentarian inherits it as settled fact. The Senate could theoretically override this. A majority vote in the moment can overrule a specific ruling, what gets called going nuclear. But the political exposure required to do so openly, and the operational cost of dismantling the entire presidential structure, has made meaningful repeal a conversation that never reaches the floor. The machine is self-sealing. To challenge it, you must move through the very procedural machinery the parliamentarian controls. And here is what this tells you about every institution built the same way. The parliamentarian is not an anomaly, it is a template. When a government body derives its authority from precedent rather than statute, that authority becomes structurally invisible. It does not appear on the organizational chart you were taught in school. It does not require reauthorization by the people you elected. It does not face a ballot. It simply continues, embedded in the machinery, insulated from the democratic processes that might otherwise reach it. The Senate runs dozens of inherited structures this way. Most of them do not have a name you were ever given. Most of them have never appeared in a civics textbook. Most of them are doing exactly what they were designed to do, and the design includes not being examined. So here is the question worth sitting with after this ends. If the most consequential procedural decisions in American lawmaking are being made by a staff employee operating on inherited precedent, with no public record and no repeal mechanism, what else is running on the same logic? What other rules with that same quiet force are already shaping the things you believe you voted for?